Hey, I'm Nancy Cavey. I'm a national ERISA and individual disability attorney, and I want to welcome you to Winning Isn't Easy. In this episode, I'm going to talk about Social Security disability claims and your long-term disability claim, what you need to know in the interaction between these claims. But before I get started, I have to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association tells me I've got to say that, so I've done that. But nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. Now, I will tell you that Social Security disability claims and long-term disability claims are often intertwined, and I'm going to discuss this interaction. First thing I want to talk about is what you need to know about Social Security disability listings, why you shouldn't speak with the Social Security administrator assigned to your claim, and the 3 ways that your Social Security disability attorney can destroy your ERISA disability claim. Okay? Now, before we get started, let's take a quick break. Welcome back to Winning Isn't Easy. 3 ways your Social Security disability attorney can destroy your ERISA disability claim. Winning your Social Security disability claim can hurt and even destroy your long-term disability claim. What are you saying? That doesn't make any sense. Well, let me give you 3 examples of how a Social Security lawyer can screw up your long-term disability claim. Now, why do I know that? Well, I'm a Social Security disability lawyer and an ERISA disability lawyer. And oftentimes I am asked by the Social Security attorney to try to fix the mess that they made in the long-term disability case because they didn't know what they were doing. So let's talk about the first screw up. Let's say you claim you're disabled as of January 1st in both your Social Security and your long-term disability claim. However, at the hearing, the Social Security judge says, I want you to move that date of onset to a date later than you claimed, or finds that you were disabled on a different date than what you claimed. The result can be that the disability carrier can seize on that amended date of onset and argue that you weren't disabled as of the date you claimed you were, and therefore you aren't disabled for long-term disability purposes. So the Social Security attorney in this situation doesn't understand what the impact of an amended onset has on the long-term disability claim and screws up your claim. The second thing that they can do is, let's say, as is generally common, your long-term disability policy or plan has a limited pay provision for mental nervous conditions. They'll only pay you for 2 years. But you've got multiple medical conditions, including depression, and the Social Security attorney argues you're disabled in part because of depression. You get your Social Security benefits, the Social Security judge writes an opinion and says you're disabled in part or in whole by your depression. The long-term disability carrier is going to seize on that and invoke the mental nervous policy limitation and say, your benefits were limited to just 2 years. A judge found that you were disabled as a result of your psychiatric condition. So we certainly can't be wrong. We're going to defer to the judge in this case. Now, the third screw up is, depending on your age, you can win your Social Security claim if you're limited to working in a like capacity. Now, many Social Security attorneys will get your doctor to agree that you can do light work, or the Social Security judge will find that you can do light work and award your benefits. Now, that might be okay if you're at your own occupation stage of your long-term disability claim, and your occupation wasn't one where you were sedentary and sitting all day. But it is bad news at any occupation stage, because if you can do light work, if you can do sedentary work, the long-term disability carrier is guaranteed going to deny your claim on the basis that you can do any occupation, and they are going to point to that Social Security decision. These mistakes can be hard to fix. Now, you also don't want to have a Social Security lawyer who masquerades as an ERISA disability attorney that says, I can handle your long-term disability claim. I hope that your Social Security attorney is smart enough to know that they can't, and they shouldn't be handling an ERISA disability claim. The National Organization of Social Security Claims Reps, NOSCAR, which I'm a member of, has launched an online forum devoted to long-term disability issues, which on its face sounds like a good idea, but I think it's an absolute horrible idea. According to NASCAR, the LTD Forum is a place to ask questions, give advice, share resources, and case development related to both ERISA and private long-term disability claims. Now, I'm one of the few members of NASCAR who does both Social Security disability and ERISA and private LTD work. And I've done that for over 30 years. It's not uncommon, as I've said, for me to be asked to step in and clean up a mess, if possible, that a Social Security lawyer has made while masquerading as an ERISA or private LTD attorney. Sometimes a Social Security lawyer thinks that it's just enough on appeal to send in a copy of the Social Security decision, and that's a winner. Hey, that's not even close. And there are times as a result, I can't fix the mistakes. I got to tell the client, look, here's the bad news. Your Social Security attorney screwed up your ERISA claim, and this is how they screwed it up. And your options include suing your Social Security lawyer because you've gotten screwed in your ERISA disability claim. Now, you might argue that this NASCAR LTD forum is going to help cure those problems, but I doubt it for several reasons. Why? Well, I think first it gives Social Security lawyers the feeling that they can handle these cases when they can't. It's a false sense of knowledge. And it's also a false sense of courage. They think that they can take on a case when they shouldn't, and it gives them false hope that they can bluff you and bluff a disability carrier through an ERISA disability claim. The only persons that they're bluffing, quite frankly, are themselves. ERISA and private insurance disability insurance claims are much more complex than a Social Security case. They involve ultimately federal law, federal rules of procedure, federal rules of evidence, a working knowledge of defense law, a working knowledge of defense firms and the federal judges, and crucially, understanding something called a standard of review. Most lawyers do not understand the standard of review in an ERISA disability case, and not understanding that and your appeal rights and what should be submitted in an appeal, and the fact that there is no trial like a Social Security case, are all of the things that Social Security disability lawyers screw up and think that just because they handle a Social Security case, they know how to handle an ERISA disability case. That kind of knowledge is not going to come from being a member of an online forum. So you should be very, very, very careful. If your Social Security lawyer wants to handle your ERISA or private individual disability claim, they will be learning on the job and you will be their guinea pig. So what you really want is a long-term disability lawyer who's also a Social Security lawyer. Now, I handle cases across the United States, both Social Security and long-term disability. And you want to be represented by lawyers who do both. And I admit that it can be hard to find someone, but that's what you want. Short of that, you want a Social Security lawyer, you want an ERISA disability lawyer, and you want them to be talking with each other. You want them to be sharing information. You want the ERISA lawyer to be talking to the Social Security lawyer about what's the standard of review, what's the definition of occupation, what's the definition of disability, are there policy limitations for mental nervous conditions, are there policy limitations on subjective medical conditions like back conditions or fibromyalgia, what's the impact of amending the date of disability, and you need to understand, and they need to coordinate what medical proof and vocational proof that they can develop and share that will maximize your entitlement to both Social Security disability and ERISA disability benefits. Maximizing your benefits requires communication and collaboration, not only with you, but with your Social Security disability attorney and your ERISA attorney, or if you're fortunate to find someone like me, between you and a lawyer like myself who does both Social Security and ERISA disability work. Got it? I hope that you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, please like our page, please leave a review, and share it with your friends or family. Better yet, consider subscribing to this podcast. That way you're going to get notification every time a new episode comes out. I hope you tune in to next week's insightful episode of Winning Isn't Easy. Thanks.